Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone and are not the views of my law firm, the university, or any other academic institution or entity I work with. I am the host of the Curious Lawyer Education series of programs. Today's program is on flag law and is a look at the laws on our books that relate to our flag, its treatment, flag desecration, and also a look at some cases involving Confederate flags. The flag, of course, is the national symbol, and the Pledge of Allegiance and National Anthem certainly generate pride and emotion. But what laws control the use of the flag? Can we desecrate and burn the flag? Can private HOAs delimit your right to fly a flag? Does the phrase "under one God" in the pledge violate the Establishment Clause? We will answer these questions and look at a variety of flag-related issues in the process. This will be fun and educational, so sit back and enjoy. But first, and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating look at the laws related to flags and our national signs and symbols. Let's do a quick overview of where we are going today. Our agenda of flag law, which also will have us cover some fundamentals on the Pledge of Allegiance and the National Anthem. We will look at federal laws that relate to display and use of flags, flag desecration laws. We will look at flag burning in the First Amendment and see all the twists and turns of the case law and Congress on this contentious issue. We will take a look at the federal flag laws and how they relate to commercial advertising. We will also look at the Pledge of Allegiance laws and First Amendment religion speech challenges and the Supreme Court case involving the pledge and the words "one nation under God." We will also touch on laws that relate to appropriate conduct during the National Anthem. Finally, we will take a look at some recent cases involving Confederate flags. This includes challenges to state flags with Confederate flags in them. And we will look at a criminal case where a large Confederate flag was in the jury room, and that was challenged as denying a fair trial. So let's get going. So let's start with the federal law that addresses flags. Yes, you heard it here at the Curious Lawyer first. We have a detailed set of enactments in the U.S. Code relating to flags. So let's start here with a quick overview of U.S. Flag Code, which is contained at 4 U.S.C. sections 1 through 10. We will get into it more detail over the program, but a quick framework is as follows. 1. This federal law regulating flags sets forth guidelines for private citizens and the government on the appearance and display and treatment of the U.S. flag. 2. It defines how a U.S. flag must look and display times, its use in processions and parades, and half-staff use rules. 3. It vests complete authority in President to change code enactments. 4th, the Flag Code also specifies how to deliver the Pledge of Allegiance to the flag and appropriate conduct while watching a performance of the National Anthem. And finally, most of the Flag Code contains no explicit enforcement mechanisms. And that is where we will start as we explore how this quote law, end quote, really works. This brings us to the case of a Confederate flag. Specifically, when the Confederate flag flies higher than the U.S. flag, and that was challenged. The case is called Holmes v. Wallace, reported at 407 F. Sup. 493 from the Middle District of Alabama in 1976. Let's start with the facts. Plaintiff alleged that the flying of the flag of the former Confederate States of America, immediately below that of the state of Alabama, on a halyard atop the Alabama State Capitol in Montgomery, Alabama, together with the flying of the United States flag elsewhere on the Capitol grounds at an elevation lower than that occupied by the Confederate flag, constitutes a violation of the Flag Code laws. He sued under the Flag Code, saying the Flag Code was violated. So the question before the court was whether the federal flag law gave rise to a private right of action to enforce it in the courts. What did the court hold? The court held that, quote, an examination of the Flag Code section of Title 36 as a whole leads to the conclusion that sections 173 to 178, as well as the associated sections 170 to 173, are not intended to prescribe conduct, but are merely declaratory or advisory. End quote. What this means is that the provisions are not enforceable by federal court action. In other words, the major point is that the law codified customs and etiquette, but is not designed to compel behavior by force of law. This was affirmed by the Fifth Circuit and is consistent across courts that have addressed this issue. What does the flag law say about how the flag must appear? Here is Section 1 of the Act. The flag of the United States shall be 13 horizontal stripes, alternate red and white, and the union of the flag shall be 48 stars, white in a blue field. 48 stars, you say? We have 50 states. Yes, the law was written before Hawaii and Alaska joined the Union, but it was written with an eye to new states potentially joining. And so we can see in Section 2 the following, quote, on the admission of a new state into the Union, 1 star shall be added to the union of the flag, and such addition shall take effect on the 4th day of July, then next succeeding such admission. End quote. So we are safe, the 50-star flag counts today. But beyond the number of stars and stripes and color scheme, the legislative history and executive enactments even specify dimensions and placement of all the components relative to each other. And so we see it here on this slide, the relative size relationship of all the components. It's incredible, and that's in our law books. Amazing. Now let's turn to the Pledge of Allegiance to the flag, which also is codified in law. Of course, we all know it, and it goes, quote, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. End quote. That is part of Section 4 of the statute. Now, the law further makes clear how we should say it. Specifically, it should be rendered by standing at attention facing the flag with the right hand over the heart. When not in uniform, Men should remove any non-religious headdress with their right hand and hold it at the left shoulder, the hand being over the heart. Persons in uniform should remain silent, face the flag, and render the military salute. Members of the armed forces not in uniform and veterans may render the military salute in the manner provided for persons in uniform. So there you have it. Next time you are at a concert or ball game or a school event, and the pledge is said, now you know that the acts we engage in and learn from a young age are not just custom, but actually decreed by the U.S. Code. Tell that to your friends at the next cocktail party. This, though, brings us to the Religion Establishment Clause questions that have been raised about the pledge, and this will bring us to the Ninth Circuit. The pledge, of course, has generated controversy over the years, as there was substantial litigation in the early 2000s over whether the pledge being said in schools, where one was forced to hear the words "Peony Nation Under God," affected an establishment of religion. We are going to look at the cases that went to the Supreme Court, principally a case brought by a father who was an atheist and did not like the fact that his daughter was hearing that phrase in school. His name was Michael Newdow, and he brought a pro se lawsuit. Incredibly, his pro se lawsuit went all the way to the Supreme Court, where he himself actually argued it. So let's start by hearing a part of his actual argument in his words to understand the issue as he saw it, and then we will go through the case law.
Thank you, General Olson. Mr. Newdow, we'll hear from you. Am I pronouncing your name correctly?
Yes, you are.
Please proceed.
Mr. Chief Justice, and may it please the Court. Every school morning in the Elk Grove Unified School District's public schools, government agents, teachers, funded with tax dollars, have their students stand up, including my daughter, face the flag of the United States of America, place their hands over their hearts, and affirm that ours is a nation under some particular religious entity, the appreciation of which is not accepted by numerous people, such as myself. We cannot in good conscience accept the idea that there exists a deity. I am an atheist. I don't believe in God. And every school morning, my child is asked to stand up, face that flag, put her hand over her heart, and say that her father is wrong.
Well, now
So you can see there the core issue for Mr. Newdow. So let us now explore the case law that led him to arrive at the Supreme Court. Of course, this issue of the pledge and the First Amendment revolves around the words "under God." The question courts have confronted is whether that phrase violates the First Amendment by forcing an establishment of religion. Let's take this step by step as it is percolated in the courts. The first case was Newdow versus U.S. Congress, reported at 328 F. 3rd 466 from the Ninth Circuit in 2002. Here, the Ninth Circuit held that daily recitations of the Pledge of Allegiance violates the Establishment Clause of the First Amendment. This court reasoned that the school had placed its students in the untenable position of choosing between participating in the pledge or protesting it, and that the monotheistic religious content of the pledge was not trivial. Here's what the Ninth Circuit held, finding this coercive. The coercive effect of the policy here is particularly pronounced in the school setting, given the age and impressionability of school children, and their understanding that they are required to adhere to the norms set by their school, their teacher, and their fellow students. Now there was a dissent from Judge Fernandez. Here's what he said, quote, "But legal world abstractions and ruminations aside, when all is said and done, the danger that under God in our Pledge of Allegiance will tend to bring about a theocracy or suppress somebody's beliefs is so minuscule as to be de minimis. The danger that phrase presents to our First Amendment freedoms is picayune at most." End quote. After this ruling, this case went to the Supreme Court. It reversed on other grounds, holding that the child's father, who had disputed custody over his child, lacked standing to bring the case. So that was a punt. Newdow revisited his challenge with standing, and this time the Ninth Circuit went the other way. The court held that Congress had two main purposes for keeping the phrase, quote, "nation under God," end quote, in the pledge. First, to underscore the political philosophy of the Founding Fathers that God granted certain inalienable rights to the people which the government cannot take away. And second, to add the note of importance which a pledge to our nation ought to have and which in our culture ceremonial references to God arouse. So Judge Fernandez's dissent ultimately prevailed, and the Ninth Circuit the next time out found the phrase not to be unconstitutional. Other similar challenges were tired in other circuits, and those circuits similarly found no constitutional violation. You can see the cases there if you want to go read them from the First, Fourth, and Seventh Circuits. So here's the bottom line as it comes to the pledge. One cannot be forced to say it, but one also cannot stop it being said in schools and hearing the words "one nation under God." Let's look now at the time and manner of display, found in 4 U.S.C. Section 6. Here's what it says. It is the universal custom to display the flag only from sunrise to sunset on buildings and on stationary flagstaffs in the open. However, when a patriotic effect is desired, the flag may be displayed 24 hours a day if properly illuminated during the hours of darkness. Further in subsection C it says, the flag should not be displayed on days when the weather is inclement, except when an all-weather flag is displayed. And in subsection D it says, quote, the flag should be displayed on all days, especially on New Year's Day, January 1st, Inauguration Day, January 20th, Martin Luther King Jr.'s birthday, third Monday in January, Lincoln's birthday, February 12th, Washington's birthday, third Monday in February, National Vietnam War Veterans Day, March 29th, Easter Sunday, variable, Mother's Day, second Sunday in May, Armed Forces Day, third Saturday in May. It's long as you can see, listing all the holidays. So let's continue. Memorial Day, half-staff until noon, the last Monday in May. Flag Day, June 14th. Father's Day, third Sunday in June. Independence Day, July 4th. National Korean War Veterans Armistice Day, July 27. Labor Day, first Monday in September. Constitution Day, September 17th. Columbus Day, second Monday in October. Navy Day, October 27th. Veterans Day, November 11th. Thanksgiving Day, fourth Thursday in November. Christmas Day, December 25th, and such other days as may be proclaimed by the President of the United States, the birthdays of states, date of admission, and on state holidays. End quote. So as you go to your next election polling booth and see a flag, it is no mere coincidence. This law actually also talks about the importance of the flag being there and at schools. It says, quote, the flag should be displayed in or near every polling place on election days, end quote. And as to schools, it says, the flag should be displayed during school days in or near every schoolhouse. But how should it be displayed physically? Let's take a look at what the law says. Section 7 addresses the position and manner of display. There are myriad subsections addressing all manner of aspects to this, so I have just reproduced a few of them for you to get a flavor of the law. Let's look at subsections B, D, E, and L. First, Section B addresses how it is placed on vehicles. Quote, the flag should not be draped over the hood, top, sides, or back of a vehicle or of a railroad train or a boat. When the flag is displayed on a motor car, the staff shall be fixed firmly to the chassis or clamped to the right fender. End quote. Second, the law looks at how it is displayed with other flags in unison. Quote, the flag of the United States of America, when it is displayed with another flag against a wall from crossed staffs, should be on the right, the flag's own right, and its staff should be in front of the staff of the other flag. End quote. Third, and related, quote, the flag of the United States of America should be at the center and at the highest point of the group when a number of flags of states or localities or pennants of societies are grouped and displayed from staffs. End quote. Finally, the detail is down to how it is used at ceremonies with statues. It says, quote, the flag should form a distinctive feature of the ceremony of unveiling a statue or monument, but it should never be used as the covering for the statue or monument. End quote. This brings us to the half-staff rules, in terms of when we fly the flag at half-staff or half-mast, as some say. Let's first get the code's definition of what half-staff even means. It says in section M1 that the term half-staff means the position of the flag when it is 1/2 the distance between the top and bottom of the staff. So here's the substance of it. The flag, when flown at half-staff, should be first hoisted to the peak for an instant and then lowered to the half-staff position. The flag should be again raised to the peak before it is lowered for the day. On Memorial Day, the flag should be displayed at half-staff until noon only, then raised to the top of the staff. By order of the President, the flag shall be flown at half-staff upon the death of principal figures of the United States government and the governor of a state, territory, or possession, as a mark of respect to their memory. In the event of the death of other officials or foreign dignitaries, the flag is to be displayed at half-staff according to presidential instructions or orders, or in accordance with recognized customs or practices not inconsistent with law. Now it also addresses when and for how long it is flown after a death of certain people. The flag shall be flown at half-staff 30 days from the death of the president or a former president, 10 days from the day of death of the vice president, the Chief Justice or a retired Chief Justice of the United States, or the Speaker of the House of Representatives, from the day of death until interment of an Associate Justice of the Supreme Court, a Secretary of an executive or military department, a former Vice President, or the Governor of a state, territory, or possession, and on the day of death and the following day for a member of Congress. The flag shall be flown at half-staff on Peace Officers' Memorial Day, unless that day is also Armed Forces Day. So there you have it. When there are deaths of these heads of state, and we see our flags lowered, the length of time they remain lowered is coming from this code. The code also has a series of thou shalt not commands in terms of things that should never be done with the flag. There are many, and so again I've selected a few for us to discuss, but it is well worth reading the full list. Let's take a look at these ones. First, the flag should never be displayed with the union down, except as a signal of dire distress in instances of extreme danger to life or property. Second, the flag should never touch anything beneath it, such as the ground, the floor, water, or merchandise. Third, the flag should never be carried flat or horizontally, but always aloft and free. Fourth, the flag should never be used as a receptacle for receiving, holding, carrying, or delivering anything. Next, the flag should never be used for advertising purposes in any manner whatsoever. It should not be embroidered on such articles as cushions or handkerchiefs and the like, printed or otherwise impressed on paper napkins or boxes or anything that is designed for temporary use and discard. Advertising signs should not be fastened to a staff or halyard from which the flag is flown. Now we will come back to this advertising issue shortly, but let us continue with one more. Finally, the flag, when it is in such condition that it is no longer a fitting emblem for display, should be destroyed in a dignified way, preferably by burning. So let's turn now to flag desecration, as well as this federal law that says not to desecrate the flag. There are myriad state laws that also prohibit it, along with actual legal punishments for doing it. Here is a sampling where I have tried to cover the political spectrum, so you can see that state laws cross perceived political orientations of states. Louisiana law imposes a fine of up to $2,000 for casting contempt upon the United States flag by intentionally setting fire to it. And Mississippi law imposes various penalties for desecration of U.S. or Mississippi flag. Similarly, California makes it a misdemeanor for a person to knowingly desecrate the flag. And finally, Washington makes it a gross misdemeanor to knowingly cast contempt upon a flag by desecration. Of course, the central question we must address now is whether these laws that can criminalize desecrating the flag violate the First Amendment. This will bring us to the Supreme Court, so let's get going, and we will travel back in time to the 1960s. As we see how the Supreme Court has managed flag desecration, we will do that by going through a trilogy of cases. The first case is Street v. New York from 1969. In Street v. New York, the court considered a challenge to a law that made it a misdemeanor to publicly mutilate, deface, defile, or defy, trample upon, or cast contempt upon either by words or act any flag of the United States. There, the defendant, learning of the shooting of civil rights activist James Meredith, burned a flag on a Brooklyn street corner while stating, quote, "Yes, that is my flag. I burned it. If they let that happen to Meredith, we don't need an American flag." End quote. The court first concluded that the trial record did not establish whether the defendant's conviction had been for burning the flag or for the accompanying words, so it considered either as possible grounds for the conviction. The court evaluated the purported governmental interest in punishing the defendant's words, rejecting the argument that the government's intent was to deter the incitement of unlawful acts. The court next held that the speech in question was not fighting words. That is, it did not involve words so inherently inflammatory that they were likely to provoke the average person to retaliations, and thereby cause a breach of the peace. Nor, the court concluded, was the statute narrowly drawn to punish only words of that character. Further, the court dismissed the argument that government interests in avoiding shocking or disrespectful speech outweighed the freedom to express one's opinions about the flag. Finally, the court concluded that freedom of speech protected public expression of opinions about the flag, even if such opinions are defiant or contemptuous. Because it had sufficient basis to overrule the conviction based on the spoken words alone, the court declined to pass upon the validity of the New York law as applied to the flag burning. So flag burning was allowed, but not centrally, as symbolic protected speech, and was permitted by way of vacating the conviction, because the words spoken with the act were protected. This requires us to keep moving along to see how the central act of flag burning fares in the law. This brings us now to the second case, Spence v. Washington. It is reported at 418 U.S. 405 and is from 1974. In this case, a college student was convicted under a Washington state improper use law for affixing a peace symbol made of removable tape to a U.S. flag and hanging the flag upside down from an apartment window. The defendant testified that he had put the peace symbol on the flag as a protest against the Cambodian invasion and the killing of students at Kent State University during anti-war protests. The court held that the Students' Act was symbolic speech, an activity imbued with communication. The court also held there were no facts to support a breach of the peace, nor was there a valid governmental interest in avoiding offensive speech. The court concluded that the flag had not been damaged by the removable tape, so maintaining the physical integrity of the flag was not at issue. Thus, the court concluded that no governmental interest existed to support the conviction within the contours of the First Amendment. So like the first case, the First Amendment triumphed over damage being done to a flag. Now this was not a flag-burning case, and although it arguably desecrated the flag, it did not do so permanently since the peace symbol was affixed to the flag. This brings us to the last time the Supreme Court addressed flag burning in 1989. This is the seminal case of Texas v. Johnson from 1989. Here are the facts. Gregory Lee Johnson burned an American flag outside of the 1984 Republican National Convention in Dallas, Texas. Johnson burned the flag to protest the policies of President Ronald Reagan. He was arrested and charged with violating a Texas statute that prevented the desecration of a venerated object, including the American flag, if such action were likely to incite anger in others. In turn, a Texas court tried and convicted Johnson. The issue for the court was whether flag burning constitutes symbolic speech protected by the First Amendment. In a split 5-4 decision, the court held that expression may not be prohibited on the basis that an audience that takes serious offense to the expression may disturb the peace, since the government cannot assume that every expression of a provocative idea will incite a riot, but must look to the actual circumstances surrounding the expression. burning a flag is not inciting a riot or imminent fisticuffs trigger. Quote, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. End quote. Quote, to conclude that the government may permit designated symbols to be used to communicate only a limited set of messages would be to enter territory having no discernible or defensible boundaries. Could the government, on this theory, prohibit the burning of state flags, of copies of the presidential seal, of the Constitution? In evaluating these choices under the First Amendment, how would we decide which symbols were sufficiently special to warrant this unique status? To do so, we would be forced to consult our own political preferences and impose them on the citizenry in the very way that the First Amendment forbids us to do. End quote. That was the majority, then, that found the flag-burning conviction violated the First Amendment. But there was a passionate dissent by 4 of the members, so let us look at that now. Here is what Justice Rehnquist wrote. Quote, the American flag, then, throughout more than 200 years of our history, has come to be the visible symbol embodying our nation. Far from being a case of one picture being worth 1,000 words, flag burning is the equivalent of an inarticulate grunt or roar that, it seems fair to say, is most likely to be indulged in not to express any particular idea, but to antagonize others. The Texas statute deprived Johnson of only one rather inarticulate symbolic form of protest, a form of protest that was profoundly offensive to many, and left him with a full panoply of other symbols and every conceivable form of verbal expression to express his deep disapproval of national policy. End quote. This dissent had an underlying rationale built around the idea that the court was willing to allow states to restrict speech that was offensive to many because of nature of the importance of the speech at issue, and so saw a path to restricting speech based on its level of offensiveness. Here, given the role of the flag and the offense at burning, the dissenters believed the offensive speech could be regulated more. So we should unpackage this split more. And to do that, let's turn to some of the actual oral argument in the Supreme Court that led to this decision. Let's now see how the oral argument in this contentious case went, because as we see from the split of the court, there was a major policy difference between the majority and dissent. One vote the other way and flag burning would not have been allowed. Let's listen right now to a few minutes of the oral argument here from the 1989 case. We pick up the Supreme Court oral argument about 3 minutes in from the beginning with a question from Justice Scalia. And then you will hear Justice Rehnquist joins the questioning of the Texas State Attorney.
Protect the symbol.
Now, why did the defendant's actions here destroy the symbol? His actions would have been useless unless the flag was a very good symbol for what he intended to show contempt for. His action does not make it any less a symbol.
Your Honor, we believe that if a symbol over a period of time is ignored or abused, that it can, in fact, lose its symbolic effect.
I think not at all. I think when somebody does that to the flag becomes even more a symbol of the country. I mean, it seems to me you're running quite a different argument. Not that he's destroying its symbolic character, but that he is showing disrespect for it. That you not just want a symbol, but you want a venerated symbol. And you don't make that argument because then you're getting into a sort of content preference. But I don't see how you can argue that he's making it any less of a symbol than it was.
Your Honor, I'm forced to disagree with you because I believe that every desecration of a flag carried out in the manner that he did here, and certainly I don't think there can be any question that Mr. Johnson is a hardcore violator of this statute. If his actions in this case, under the facts of this case, do not constitute flag desecration, then I really am not quite certain what would constitute flag desecration.
They desecrate the flag, indeed, but do they destroy the symbol? Do they make it any less symbolic of the country? That's the argument I thought you were running. that we have a right to have a national symbol. And if you let the people desecrate the flag, we won't have a national symbol. I don't see how that follows. We may not have a respected national symbol, but that's a different argument. Now, if you want to run that argument that we have the right to insist upon respect for the flag, that's a different argument.
Texas is not suggesting that we can insist on respect. We are suggesting that we have the right to preserve the physical integrity of the flag so that it may serve as a symbol, because its symbolic effect is diluted by certain flagrant public acts of flag desecration.
Well, in a sense, you're arguing a minimal form of respect for the flag, aren't you? Not that you have to take your hat off or salute when it goes by. Now, the state can't require it, but at least it can insist that you not destroy it.
Yes, Your Honor, to the extent that we are asking for any respect for the flag, we are asking for respect for its physical integrity. Certainly, we do not demand that any individual view it with any discernible emotion whatsoever. Only that its physical integrity be respected. And I think that is a very minimal basis to ask from any individual. And that is really all Texas is suggesting with this, is that we have got to preserve the symbol by preserving the flag itself, because there really is no other way to do it.
So we can see there this big debate that broke Scalia and Rehnquist in terms of the flag and its value as a symbol, and whether that can be demanded by way of criminal laws that delimit the right to desecrate it. They just came out on different sides of that question, even though they generally lined up together. Once we see that difference between the jurists, this of course lets us ponder, how would they decide it today on this court? Will they revisit it? Would the conservatives today go with the foreign dissent from 1989? The split in 1989 was definitely curious and was not a pure political ideological split. Back then, the five in the majority were the traditional liberals, Justices Brennan, Blackmun, and Marshall. But they were joined by traditional conservatives Scalia and Kennedy, the latter perhaps more middle of the road over the years. Yet the dissenters included Stevens, who was part of the liberal bloc often, and conservatives O'Connor, Rehnquist, and White. So as we can see with the Stevens and Scalia votes, this issue did not sit firmly on traditional ideological political lines. So let's all stay tuned and see if our contentious times today cause a revisit of the flag burning issue. This issue of flag burning is very socially contentious. Indeed, in response to Texas v. Johnson, Congress passed the Flag Protection Act in 1989. It provided that anyone who knowingly desecrates the flag may be fined and/or imprisoned for up to 1 year. Specifically, the law provided for a prison term of up to 1 year for anyone who knowingly mutilates, defaces, physically defiles, burns, maintains on the floor or ground, or tramples upon any United States flag. Here is what President Bush said at the time. Quote, "Nevertheless, because this bill is intended to achieve our mutual goal of protecting our nation's greatest symbol, and its constitutionality must ultimately be decided by the courts, I have decided to allow it to become law without my signature. I remain convinced, however, that a constitutional amendment is the only way to ensure that our flag is protected from desecration." End quote. So as he saw coming, the law was challenged, and the Supreme Court got the case again. This was the case of United States versus Eichmann. It is reported at 496 U.S. 310 and came right away after the law was enacted in 1990. The government tried to argue the law was valid because the Flag Protection Act did not target expressive conduct, but was intended to protect the physical integrity of the flag in order to safeguard the flag's identity as the unique and unalloyed symbol of the nation. But the court held that the mere destruction of a U.S. flag did not affect the significance of the flag as a symbol of national unity unless that destruction was done with the intent to communicate a message. Further, the language of the act that prohibits mutilating, defacing, defiling, or trampling upon a flag, the court held, connotes disrespectful treatment of a flag in order to damage the flag's symbolic value. And the statutory exception for disposal of worn or soiled flags exempts acts traditionally associated with patriotic respect for the flag. Thus, the court held that the act was a regulation of expressive activity and, consistent with its decision in Johnson, struck it down. And as with the Texas case from 1989, the 1990 case had the same 5-4 split in the Supreme Court. This led to resolutions along the lines President Bush called for to amend the Constitution to prohibit flag burning, but those did not to ever pass. So the Supreme Court has now twice protected flag burning. Now we turn to advertising. Here is what the code says. Any person who, within the District of Columbia, in any manner, for exhibition or display, shall place or cause to be placed any word, figure, mark, picture, design, drawing, or any advertisement of any nature upon any flag, standard, colors, or ensign of the United States of America, or shall expose or cause to be exposed to public view any such flag, standard, colors, or ensign upon which shall have been printed, painted, or otherwise placed, or to which shall be attached, appended, affixed, or annexed any word, figure, mark, picture, design, or drawing, or any advertisement of any nature, or who, within the District of Columbia, shall manufacture, sell, expose for sale, or to public view, or give away, or have in possession for sale, or to be given away, or for use for any purpose, any article or substance being an article of merchandise, or a receptacle for merchandise, or article or thing for carrying or transporting merchandise, upon which shall have been printed, painted, attached, or otherwise placed a representation of any such flag, standard, colors, or ensign, to advertise, call attention to, decorate, mark, or distinguish the article or substance on which so placed shall be deemed guilty of a misdemeanor and shall be punished by a fine not exceeding $100 or by imprisonment for not more than 30 days, or both, in the discretion of the court. And the key definition says, quote, the words flag, standard, colors, or ensign, as used herein, shall include any flag, standard, colors, ensign, or any picture or representation of either or of any part or parts of either, made of any substance or represented on any substance, of any size evidently purporting to be either of said flag, standard, colors, or ensign of the United States of America, or a picture or a representation of either, upon which shall be shown the colors, the stars, and the stripes, in any number of either thereof, or of any part or parts of either, by which the average person seeing the same without deliberation may believe the same to represent the flag, colors, standard, or ensign of the United States of America. End quote. Wow. So as you can see, there is a fine and power of the prosecutors to punish the use of the flag in advertising. Can this law stand as against the First Amendment? First, no court has directly addressed whether the use of a U.S. flag in advertising is commercial speech. This makes the answer uncertain. Second, the question is, does the flag add to expressive content of commercial advertising and convey any information about a product service? One difficulty in analyzing this issue is that the display of a flag in advertising appears to add little expressive content to the commercial aspects of the advertisement. In other words, while a U.S. flag may be used in an advertisement, and its use may be economically motivated and thus commercial speech, the display of a flag is unlikely to convey information about the specific product or service. Rather, the expressive content of displaying the flag would appear to be to link the product or service to a political message such as patriotism or national pride. Thus, even with lower First Amendment protection for commercial speech, likely would be lawful. For instance, while concerns about avoiding a breach of the peace is a substantial governmental interest, it seems unlikely that, given Supreme Court commercial speech law, the court would find that prohibiting using a flag for commercial advertising was intended to avoid a breach of the peace, or any idea about preserving the physical integrity of a privately owned flag would be unlikely to be a sufficient government interest to outweigh the suppression of expressive advertising conduct. Let's now look at the National Anthem, which often goes hand in hand with the flag, of course. The National Anthem is also enshrined in federal law, specifically 36 U.S.C. Section 301. It first says that the Star-Spangled Banner is the official national anthem. It then defines appropriate conduct during the playing. Specifically, during a rendition of the national anthem, when the flag is displayed, individuals in uniform should give the military salute at the first note of the anthem and maintain that position until the last note. Next, members of the armed forces and veterans who are present but not in uniform may render the military salute in the manner provided for individuals in uniform. And, finally, all other persons present should face the flag and stand at attention with their right hand over the heart. And men not in uniform, if applicable, should remove their headdress with their right hand and hold it at the left shoulder, the hand being over the heart. And when the flag is not displayed, all present should face toward the music and act in the same manner they would if the flag were displayed. So there you have it. When we stand and listen or sing along to the national anthem, that conduct we engage in is not just custom, but is actually defined and described by Congress in the Code. Let's do a quick sidebar and a fun little thought experiment on the national anthem and talk about its copyright ability, if any. Of course, normally musical compositions and lyrics, the two major components of songs, are entitled to copyright protection by the original authors who write the musical composition and lyrics. And of course, if you want to learn more about this in detail, you can find many programs we have done on intellectual property, music, and copyright specifically to explore these issues in a fun and interesting way. So the question we ask quickly here is, does the national anthem have copyright protection? It turns out that there is a specific exception in the Federal Copyright Act for works created by the federal government. Specifically, in Title 17 of the U.S. Code at Section 105, it states, quote, "Copyright protection under this title is not available for any work of the United States government, but the United States government is not precluded from receiving and holding copyrights transferred to it by assignment, bequest, or otherwise." End quote. To be in the public domain, U.S. government works must be created by a federal government employee as part of their official duties. But federal employees retain copyright protection in their works in certain situations. For example, an employee who writes a screenplay in the evenings at home would own the copyright. So to the extent the work is one of the federal government by the enactment and creation of the song or lyrics, it would be public domain. This means any one of us can record our own version of the national anthem and sell it. And the lyrics themselves are from 1848, so regardless of who wrote them, author in or out of the federal government, those are public domain now anyway. But hold on. Now you think that you can make all the copies you want of Whitney Houston's famed rendition of the national anthem at the 1991 Super Bowl? No, you cannot. This is because her version of it, her sound recording of it, is copyright protected to her as the author of that version. So we can all make our versions of it, but we cannot copy others' versions of it. So that was a fun and quick sidebar to give you a little bit about the copyright laws and the national anthem. But let's now get back to our program. Now let us take a look at a case that was litigated involving an ordinance that required residents to stand and salute the American flag while the Star-Spangled Banner was performed. Now this was a 1928 city ordinance on the books. It was not actually being enforced. The law had been enacted at request of Veterans of Foreign Wars organization, but the plaintiff learned about it and decided to sue. Before it was adjudicated in any way, the city repealed the ordinance. Let us now get back to the flag, and we ask the question, do you have a right to display the flag privately as against other enactments or contracts, such as homeowner rules for HOA communities? Let's start with what the federal law says. This is Section 5 of the Flag Act. The following codification of existing rules and customs pertaining to the display and use of the flag of the United States of America is established for the use of such civilians or civilian groups or organizations as may not be required to conform with regulations promulgated by one or more executive departments of the government of the United States. Fair enough, but how has that played out in court cases? Let's look at the Costanza case. Here are the basic facts. In May 2013, Costanza began displaying the American flag outside the door to his townhouse. The association has advised Costanza that his flag display violates the party's covenants and restrictions applicable to his townhouse. In this case, Costanza then challenged the HOA rules that delimited flying of flags. He argued that the rule violated the federal flag laws we have looked at. What did the court hold? It said, quote, "Noticeably absent from the text of the act is an express creation of a private right of action, any explicit enforcement mechanism or remedy, or any reference to penalties or sanctions to be imposed for violations. The act is simply an example of poor draftsmanship," end quote. In other words, the words are aspirational, but not self-enforcing or executing with a private right of action. And this federal court was unwilling to infer a private right of action either. Thus, Congress needed to say and enact more to make the law have teeth of the enforceable kind. Thus, there is no enforcement mechanism. Therefore, private rules and HOAs can delimit the so unless there is some state law that says otherwise and is actionable. You are out of luck if you agree to those HO right to fly the flag. So, unless there is some state law that says otherwise and is actionable, you are out of luck if you agree to those HOA rules. Now, here is something really unique about this law. Section 10 says this, quote, "Any rule or custom pertaining to the display of the flag of the United States of America set forth herein may be altered, modified, or repealed, or additional rules with respect thereto may be prescribed by the Commander-in-Chief of the Armed Forces of the United States whenever he deems it to be appropriate or desirable, and any such alteration or additional rule shall be set forth in a proclamation," end quote. All of the rules and customs enacted through the law related to displaying the flag may be altered or changed by executive order. That is an incredible grant of authority to let the president rewrite those rules by executive order. And this makes the act particularly unique, as it is a rare enactment of Congress that proceeds to let the executive know that he or she can, at any time, modify parts of what Congress decided was the appropriate standard it set in the law. Now let's turn to a couple of cases involving the Confederate flag and how that has played out in litigation. The first issue is when state Confederate flags are challenged. Here are the facts of Moore versus Bryant from the Fifth Circuit in 2017. The Mississippi state flag had a Confederate battle flag in the upper left corner. Plaintiff, a state prosecutor, sued and said that the use of the Confederate symbol amounted to state-sanctioned racial discrimination. Specifically, plaintiff first alleges that he is unavoidably exposed to the state flag, and that the flag's message is painful, threatening, and offensive to him, makes him feel like a second-class citizen, and causes him both physical and emotional injuries. At its core, plaintiff's injury theory is that the Mississippi state flag stigmatizes him. Plaintiff also alleged having to see flag at his place of work, the courthouse, created a hostile work environment. The Fifth Circuit held two things that are important. First, exposure to a discriminatory message without a corresponding denial of equal treatment is insufficient to plead injury in an equal protection case. That is, the injury was too amorphous to be actionable. Second, plaintiff's exposure to the Mississippi flag in courtrooms where he practices and his alleged physical injuries resulting from that exposure demonstrate that he strongly feels the stigmatic harm flowing from the flag. But plaintiff's hostile workplace and physical injury theories are insufficient to plead injury in fact. So both of plaintiff's theories failed and the case was dismissed at the pleading stage. The bottom line then is that hurt or injury from seeing a Confederate flag is not enough to give one standing to make a constitutional claim about having to see it. In some sense, this is the flip side of the flag burning case. That is, exposure to stuff with flags we may not like is not actionable ultimately. We can be forced to witness flag burning even though we may find that offensive and harmful, and we may be forced to see official state flags that by state law retain Confederate flag symbols, something we also may find offensive and harmful. Both cases thus broadly stand for the proposition that the First Amendment does not give us an unfettered right to be free from being offended. Now let's look at another flag angle. Here we look at the issue of Confederate flags in the jury room. This is the case of State v. Gilbert, case number CR 114803 from the Criminal Court of Appeals of Tennessee from August 10, 2021. Here are the facts. An all-white jury deliberates a criminal case against a black defendant, and Confederate flag was on the wall in the jury room. The jury found him guilty and he got a 6-year sentence. Gilbert argued that using a room maintained by the United Daughters of the Confederacy and ornamented with relics of the Confederacy for jury deliberations exposed the jury to extraneous prejudicial information and violated his constitutional right to a fair trial by an impartial jury, as well as due process and equal protection under the law. The appellate court held that defendant was prejudiced by the jury's exposure to the Confederate memorabilia in the room, and so granted him a new trial. Here the idea in the case, as the opinion discusses, is that flags communicate messages pertaining to, say, a government's identity, values, and military strength. Flags have been used throughout history to communicate messages and ideas. Thus, the flag itself is what conveyed extraneous information to the jury and created prejudice. So here we see a case on the other side of the line where display of it is actionable vis-a-vis one's fair trial rights. This is the case of Holmes v. Hunt from the 1990s. This case involved the Confederate battle flag that had flown over the Alabama state capitol since 1963. Plaintiffs filed an action to force the removal of the flag. They relied on an ancient 1891 extant law that required only official federal and state flags to be flown. In court, the state court judge enjoined then-Governor Hunt from flying the Confederate battle flag. Although the governor appealed, it was later dropped. So what this makes clear is that where there are such laws demanding official flags be flown at government facilities, it is improper to fly unofficial flags over state property. Now, this case had a lot of significance because there had been multiple prior attempts to have the flag removed and the courts had refused. Specifically, the Fifth Circuit had ruled as follows, quote, "It is unfortunate that the state of Alabama chooses to utilize its property in a manner that offends a large proportion of its population. But that is a political matter which is not within our province to decide. The remedy for such a grievance lies within the democratic processes of the state of Alabama and the voting rights of all its citizens." End quote. That was in 1990, and the old 1891 statute was not put at issue. And so the flag challenge was like the ones we looked at earlier, dealing with constitutional claims of harm from the flying of the flag. This brings us to our conclusions today in our Curious Lawyer Flag Law program that allowed us to explore the national flag, the national anthem, and the Pledge of Allegiance. First, we saw detailed federal laws on use and the treatment of flag have been held to be unenforceable as positive law, and so are declaratory and aspirational. That is, the flag code is merely advisory and does not prescribe specific behavior. Put differently, they do not create private rights of action. So if we are unhappy at how a flag is being treated, or think it is against the act, or we are denied the right to fly it by our HOA rules, then it is too bad, as we have no right to sue to enforce the act. We traced a trilogy of flag desecration cases from the Supreme Court, ending with the seminal Texas v. Johnson flag burning case. There we saw flag burning has been upheld as against state regulation or punishment under the First Amendment. Now, it was a 5-4 decision from the late 1980s and had vigorous dissents, so who knows today what would happen with today's court. But given the prior 2 cases before it, there is a strong line of First Amendment law that protects symbolic flag desecration from being punished, given the conduct is seen as being within the protection of the First Amendment. We saw how contentious the issue was, such that Congress enacted a federal law to ban flag burning after the Texas v. Johnson case. But that law was struck down right away by the Supreme Court with the same slim 5-4 majority. We are left to ponder today how would the current court treat flag burning? We also saw how hearing a required Pledge of Allegiance in school does not violate the Establishment Clause. We saw the case of Newdow that worked its way up to the Supreme Court, where Mr. Newdow argued his point, but where he ultimately lost, and the circuit courts have all agreed that students having to hear a pledge that recites the words, "One nation under God," does not establish a religion impermissibly. And we saw how the codified national anthem is the same, and old laws on the books that required standing and saluting to it have been rejected in the modern world. That gave us a fun and quick sidebar on a unique aspect of copyright law, where we addressed the fact that official federal government works are not copyright protected and are public domain. So now you can all create your own versions of the national anthem and release them on Spotify. And when it comes to the Confederate flag, we saw a few situations. First, how in a jury room its presence can deny a fair trial. Second, they cannot fly over state capitals or state buildings where state laws require only official flags be flown. And third, a Confederate flag as part of an official state flag is not actionable as equal protection injuries. Finally, you now know that all we see in the flag is spelled out in great detail in this federal act, and the actions we take in respecting the flag, handling it, and saluting it during the national anthem are not just custom, but actual enacted law. The federal enactments specify dimensions of all aspects of the flag and relative ratios of all elements to each other. I hope you have enjoyed this installment of The Curious Lawyer. As always, if you have questions, please email me, and please enjoy our other Curious Lawyer programs so that you, the Curious Lawyer, may be educated and entertained about new, fun, and off the beaten paths of the law.